Your Honor, we are live, so if we could ask all of our judges to mute their audio and their video, they could turn their video off, except for Judge Richardson, of course. Okay, sir, we are live on YouTube. The round is yours. Ms. Ogwin, please do the call of the court.
Everyone, I will now open court. Oye, oye, oye. All persons having business before the Honorable Judge Richardson in the District Court of the United States are admonished to draw near and give their attention, for the court is now sitting.
Both sides ready?
Yes, Your Honor. My name is Abigail Coco on behalf of the state of Melodia, and I'm here with my co-counsel.
Okay.
Good afternoon, Your Honor. Edmund Yarko.
Okay, and you represent, are you with?
We represent the state of Melodia.
Okay, you two are a team, correct?
Yes,
Yes,
Your
Your
Honor.
Honor.
Okay, got it. All right. And are you the plaintiffs or the defense? Just so I'm clear.
We're the prosecution.
Prosecution, state. Okay, got it. Okay.
Good afternoon, Your Honor. My name is Kevin Shang, appearing on behalf of the defendant, Lorenzo Pastore. I'm joined by my co-counsel.
Good afternoon, Your Honor. Shasta Fields for the defense.
Okay. Both sides ready?
We are ready to proceed to opening statements.
Okay. Let me just ask both sides. Who's giving opening statements from each side? From the state?
I am, Your Honor, for the
Okay.
state.
Tell me how to pronounce your last name.
Yarko?
Nyarko? Okay. Got
Yes,
it.
that's good, Your Honor.
Okay. And for the defense, are you going to give an opening statement at this time or wait until you present? Wait until the state rests.
We will be giving it at this time, Your Honor, and I will be giving that statement.
Okay. All right. Right. Okay. So, let's see. So, is it Nyarko? You're for the state and you're going first, correct?
Yes, Your Honor.
Okay. Any other preliminary matters we need to go over before we get started?
Your Honor, pursuant to the rules of this jurisdiction, there are no preliminary matters allowed.
Okay.
And also pursuant to the rule, all witnesses are sequestered.
Got it. Okay. And are we going to have the rule where the lawyer who is questioning the witness will be making the objections, or is there a tag team on objections? It's just,
That's the rule, Your Honor.
okay. All right. And because we're on Zoom, and only one person can talk at a time, be mindful of each other making objections. So once the objection is made, everybody stop talking so I can make the appropriate ruling. Everybody okay with that?
Yes, Your Honor.
Okay. All right. So tell me who's going first.
I am, Your Honor, for the state.
Okay. Okay. And I know we have a bailiff here, opening statements. What's your time on that they've given you? Is there a time limit?
Your Honor, we have 60 minutes for each side for the whole trial. And
Okay.
Yeah.
Okay. And I assume the bailiff's taking care of that. Is that correct?
Yes, Your Honor.
Okay. All right. Okay, Mr. Nyarko.
Your Honor, Exhibit 23 is a picture of Molly Teobon. It has been pre-admitted pursuant to a pretrial order. May we use it in our opening statement?
Okay. Any objections to that, or is there agreement on that?
No objection, Your Honor. It's our understanding that 23 has been pre-admitted as well.
All right. Any other exhibits for opening statements?
That's it for us, Your Honor.
Okay. For the defense, are you going to have any exhibits?
No exhibits on our side, Your Honor.
Okay. All right. Mr. Nyarko, you're on.
This is Molly Teobon. She was 27 years old. She loved soccer and Sunday lunches with her mom. A few years back, she meets a man named Lorenzo Pastore. She's immediately attracted to him. She begins to spend time with him, and for the first few months, things are great. She's totally in love and cannot get enough of him. But then things start to change. At first, Miss Teitelbaum's okay with it. Blinded by love, she accepts his behavior. But what she did not know is that the man she loved would threaten to kill her. What she could not know is that he'll make good on that threat just a few months later. The defendant went from Ms. Titelbaum's boyfriend to her killer. On September 13, 2016, the defendant silenced Molly Titelbaum forever. And that's why we're here today, to give her a voice. Now, members of the jury, cases like this are never easy to hear about, because for years, Molly Titelbaum lived in fear of her own boyfriend. But tired of living in fear, tired of being controlled, Molly Titelbaum finally gets the courage to tell the defendant that she's leaving. But instead of letting her leave, the defendant picks up his baseball bat and slams it against her head. He swings the bat against her face, then against her neck, and once more against her jaw. And as she begs for help, covered in blood and bruises, he knows that she's filing a restraining order. He knows that she'll call the police. He knows that he'll be in trouble. So the defendant swings his bat one last time until Molly Titelbaum is no longer breathing. You see, that's why Lorenzo Pastore is the defendant in today's murder case. Because Molly Titelbaum's courage to leave this relationship turned the defendant into a killer. As the prosecution will prove to you beyond a reasonable doubt that the defendant killed Molly Titelbaum willfully, deliberately, and with premeditation. We'll meet this burden when we show you why, when, and how the defendant killed Molly Titelbaum. Let's start with why the defendant killed Molly Titelbaum. You'll meet Detective Lavelle, the lead detective in this case. He'll describe a baseball bat that he saw at the defendant's house and how Ms. Titelbaum expressed her fear of the defendant. The detective will explain to you that the defendant threatened to kill Ms. Titelbaum. Now, pay close attention to what the detective found in the defendant's apartment just 3 days before Molly Titelbaum went missing. On the ground was a crumpled up piece of paper, a document that Molly Titelbaum was going to file with the court, asking for protection from the defendant. A document that would have exposed the defendant's dirty little secrets. Let's talk about when the defendant killed Molly Titelbaum. On September 13th, Molly Titelbaum went to the defendant's apartment to try to pack up her stuff and leave town. Members of the jury, that was the last time Molly was ever seen, right before she entered the defendant's apartment. No one has seen Molly Titelbaum since. Not her best friend, Sasha Nyland, and not even her own mother. For 3 years, no one knew what happened to Molly Titelbaum until a mid-20s female body was found in the nearby marsh. Listen closely, members of the jury, to evidence from the defendant's own mouth. When Ms. Titelbaum went missing, before anyone even knew that she had been hurt, the defendant knew. Detective Lavelle will explain to you that during his interview with the defendant was the first person to bring up the idea that Molly Titelbaum had been hurt. And sadly, That's what he ultimately found out, and what you hear about during this trial. That brings me to how the defendant killed Molly Titelbaum. Members of the jury, you're going to learn that this defendant did not even respect his girlfriend enough to let her get a proper funeral. Instead, he wrapped her body up in a tarp and tossed her and that bag into a filthy marsh. For 3 years, Molly Titelbaum was in that marsh. For 3 years, she started to decompose as mosquitoes infested her body. And for 3 years, this defendant got away with murder. When Ms. Titelbaum's body was found, it was so badly decomposed that we had to identify her by analyzing her teeth. You'll hear today from an expert who does exactly that. He identifies bodies using the teeth. He uses dental records of discovered bodies and compares them to the records of missing persons to see if there's a match. He'll explain to you that this body found in the marsh was indeed Molly Titelbaum. Ms. Titelbaum did not deserve to be beaten to death by the man she loved. She was a young woman just beginning her life. She tried to leave the defendant, but the defendant refused to let her go. Instead, he silenced Molly Titelbaum. But members of the jury, you can use your voice. That's why at the end of today's trial, the co-counsel will come before you and ask you to find the defendant guilty. Thank you.
All set?
Yes, Your Honor.
Okay, you can proceed. You proceed.
Molly is gone, but she's not dead. In her left hand, she has a bag. It's got the essentials: laptop, clothes, and a toothbrush. Her right hand is on the doorknob, and she takes one last look over her shoulder. One last look into what is about to be her old life. See, she knows once she walks through that door, there's no going back. So she racks her brain to make sure she's gotten everything. But she has been meticulously planning this moment for months. She knows which shelter she's going to. She knows how to change her name and information. She's even left her phone behind, so she can't be tracked. She's ready. So she opens that door, and just like that, she's gone. Members of the jury, today the evidence will show that Lorenzo Pastore did not kill Molly Titelbaum. The evidence will show that no one did. She left town forever. And that is what this case is about. Because Molly is gone. But she's not dead. Now, the prosecution bears the burden of proof in today's case, the highest burden in our legal system, proof beyond a reasonable doubt. What that means is that they must prove beyond a reasonable doubt that Molly is dead. And they must prove beyond a reasonable doubt that Lorenzo is responsible But there's 3 facts that will leave them unable to meet this burden. Molly had a plan to leave, Molly left, and Lorenzo had nothing to do with it. Let's take those one at a time. First fact, Molly had a plan to leave. Now, the prosecution just told you some bad things about Lorenzo, and we admit some of those things are true. Lorenzo was not a good boyfriend, and at times, he was not a good man. He yelled at Molly, and he threatened Molly. But we ask you to remember, he is not on trial for any of that. The state has charged him with murder. Now, the prosecution, they'll tell you that Lorenzo's behavior led him to kill Molly, but really, you'll learn that it's exactly why she planned to leave in the first place. And you'll learn this is not just our theory. This was Molly's plan. Sasha Nyland will take the stand today. He was Molly's best friend in the world. He'll tell you how he and Molly made a step-by-step plan for her to leave the state. They planned when she would leave, where she would go, how she would get there, how she would change her name, email, bank accounts, everything. How she would make sure that no one could find her. And he'll tell you how the last time he spoke with Molly, she was ready to go. All she had to do was gather her things and leave. Now, the second fact you'll learn today is that after Molly made that plan to leave, she left. The evidence will show that that is why all of her belongings are gone. That is why no one here in Walkup has seen or heard from her. Because the evidence will show that she started a new life, just like she planned. Now, the prosecution wants you to believe that the body they found in the marsh is Molly. But you'll learn today when the police found that body, it was so decomposed, it was unidentifiable. So they had to do forensic analysis. But you'll learn that that analysis was riddled with errors. You hear from a forensic expert, Dr. Morgan Ford. He'll tell you how the police made mistake after mistake in today's case. How they couldn't identify the body with DNA because the police forgot to collect any DNA. How they couldn't identify the body with dental records because the x-ray the coroner took was so blurry, it was unusable. Today, the evidence will show that there was just no way to identify that body as Molly. So that brings us to the third reason that the prosecution will be unable to prove their case. Because Lorenzo had nothing to do with it. Now, I listened very closely to the prosecution's opening statement, and there was one word we didn't hear. Eyewitness. Not one witness will take that stand today and say, I saw Lorenzo kill Molly. Not one witness will take that stand and say, I saw him get rid of the body. Not one person. Not their witnesses, not our witnesses, no one. No one will even say they saw Lorenzo with Molly after she was last seen alive with someone else. You won't hear any forensic evidence against Lorenzo either. No DNA, no fingerprints, not a single drop of blood. The prosecution will tell you a lot about a bat, but the only evidence they'll have connecting Lorenzo to that bat will be one witness who will say that 5 years ago, he thinks he remembers seeing Lorenzo with one that looked similar. Members of the jury, today we're not going to try and excuse how Lorenzo treated Molly. We won't try to defend it either. But the prosecution will tell you that's evidence of what Lorenzo did next. But what you'll learn is that it's really evidence of what Molly did next. She left. So at the end of today's trial, we'll come before you and ask that you find Lorenzo not guilty. Because Molly is gone. But she's not dead. Thank you.
First witness, ready? Or
Yes,
either
Your
do you
Honor.
giving, go ahead.
The prosecution calls Detective Jesse Lavelle.
Okay, give me just 1 second, okay? I just need to grab a pen.
Yes, Your Honor.
Okay, all set. First witness?
Hello, Detective. Please introduce yourself to the jury.
Good afternoon. I'm Jesse Lavelle, and I'm a police detective here in Waco.
How long have you been a police officer?
For about 13 years now.
And how many cases have you investigated during your 13 years of experience?
Hundreds at this point.
Were you involved in the case of the disappearance of Molly Titelbaum?
Yes, I was.
And how did you first learn of her disappearance?
Well, in September of 2016, I received a call from Molly Titelbaum's mother, Lucy Titelbaum. Ms. Titelbaum's mother reported that she hadn't shown up to their lunch plans, and that began my investigation.
How old was Miss Titelbaum when she went missing?
About 27.
Were you able to find her in 2016?
Sadly, no. The case went cold for about 3 years.
And what happened 3 years later?
A female body was found in the marsh.
What did you do when you learned about the body in the marsh?
Well, I reviewed the coroner's report and the autopsy report.
Your Honor, Exhibit 1 is the death certificate of Jane Doe on page 36 of the record. It's been pre-admitted pursuant to pretrial stipulation 24. Permission to publish that exhibit?
Any objections, Mr. Shang?
No objections, Your Honor.
Okay, submitted.
Detective, how old was the female body?
Between 25 and 50.
I'm sorry, could you say that again?
Between 25 and 50, and 30.
And what did the coroner determine was the cause of death?
The cause of death was a depressed skull fracture due to a blunt force trauma to the head.
And according to the coroner, where were those injuries?
To her head, neck, and jaw.
How did that injury occur?
She was struck in the head with a blunt force object, such as a mallet or a baseball bat.
Did you or any of the other investigating officers find an object similar to that description?
Yes, one of the analysts found a baseball bat near the body.
Your Honor, I'm referring the witness to the exhibit marked as Exhibit 18 on page 76 of the record. Opposing counsel has agreed to stipulate to its admissibility, and I offer it into evidence.
Submitted. No objections, correct? Mr. Shang?
No objections, Your Honor.
Permission to publish?
Yes, ma'am.
What is this?
That's a photo of the baseball bat that was found in the marsh.
And does it fairly, oh, I'm sorry. Tell the jury if you've seen this baseball bat before it was recovered with the body.
Yes, and I recognized it as soon as I saw it. My blood ran cold.
And why did you recognize it?
This was the exact same bat that I had previously seen with the defendant, Lorenzo Pastore.
And what was the defendant's relationship with Miss Titelbaum?
They were dating, and they had lived together for a couple of years before the incident.
Where did you see the defendant with this baseball bat?
At their apartment.
And when did you see the defendant with that baseball bat?
I saw it 2 different times. The first time just 5 months before Molly Titelbaum went missing, and the second time just 3 days before she went missing.
I want to talk about the first time, which was 5 months before the disappearance. What happened then?
Well, I received a 911 call on April 9th, 2016, and my partner and I went to the defendant's apartment as a result of that call.
And what did you hear when you got there?
When we arrived, we heard the defendant yelling at Molly Titelbaum, and when we went in, we saw that he was actually yelling at her through a bathroom door where she was hiding.
You said that you heard the defendant yelling. What was he saying?
Well, he was yelling at her, "You better come out now so I can finish what I started."
And what was the defendant holding while he was yelling at Miss Titelbaum?
I saw that he was holding a baseball bat, pacing back and forth around the room.
And what did that baseball bat look like?
It was the same bat that we just saw, about 32 inches long, and it was black and white with gold lettering.
After you saw the defendant holding that baseball bat and yelling at Molly, what did you do?
I left him with my partner and immediately went to check on Molly Teitelbaum.
Where was she at that time?
She was locked in the bathroom.
And what did she say when she came out?
She stated that the defendant told her that he would kill her to make sure that no one saw how hurt she was.
Oh, let's turn to that second time that you saw the defendant with that bat, just 3 days before she went missing. Could you tell us about that?
Sure. I saw the bat again at the defendant's apartment.
And I'm sorry, did someone say something?
No.
Who was there when you got there?
Molly Teitelbaum and the defendant.
And what was Miss Teitelbaum's condition?
She was crying and holding her face in pain.
Objection, Your Honor. Improper character evidence under Rule 404. May I be heard outside the presence of the jury?
What are the competition rules on hearings outside the presence of the jury? Do we have those?
Yes, Your Honor.
Okay.
Under this line of, Your Honor, under this line of questioning, the prosecution is attempting to elicit testimony that my client had injured Ms. Teitelbaum previously. This is improper character evidence showing that my client had injured Molly Teitelbaum previously and that he acted in action conformity therewith when he allegedly killed her.
Are we talking about the most recent incident before she died or the one that was months before?
The most recent, Your Honor.
Okay. Ms. Coco, any response?
Yes, Your Honor. This incident is not offered for propensity, but to show intent and motive. The defendant was heard making statements about how he would kill her to avoid going to prison for what he had done. And Miss Teitelbaum was seen gesturing toward that baseball bat that he'd used in the past to hurt her. And with all due respect to opposing counsel, his objection is a little late.
Just for clarification purposes, you start off with the incident that was months before, correct?
Correct.
And now we're in the incident that's 3 or 4 days before?
Correct.
Your Honor, may I be heard?
Mr. Chang, go ahead.
In the previous incident, there were descriptions of a police officer arriving on a location and hearing certain things. No objection was made. Here, the objection is to the description of injuries and anything regarding Molly's appearance or condition in that time. We believe that this would be improper character evidence to show that Lorenzo Pastore hurt Molly Teitelbaum, and any descriptions of my client hurting Molly Teitelbaum is improper character evidence.
Okay. All right. Two things. Number one, the objection is timely. Number two, it's overruled at this time. You can proceed, Ms. Coco.
What was Miss Teitelbaum's condition, Detective?
And she was crying and holding her face in pain.
And did you see the bat at that time?
Yes, it was lying on the floor near Miss Teitelbaum.
What did you ask Miss Teitelbaum about what had happened?
Well, I tried to ask her what had happened, but she was crying and she couldn't speak. All she could do was gesture towards that baseball bat that I'd seen before.
And did the defendant say anything?
Objection, Your Honor.
night?
Hearsay.
Go ahead, Ms. Coco. Your response?
Yes, Your Honor. This is an excited utterance. The detective just testified that she was crying and holding her face in pain, and therefore she is still under the stress of what had just happened to her.
Okay. It's overruled.
What did Miss Teitelbaum tell you about what had happened?
Again, I tried to talk to her. I just thought it would be too cruel to talk to her in her current condition. She really couldn't talk to me. And so all she could do was gesture towards that baseball bat that I'd seen before.
And did the defendant say anything that night?
I'll never forget it. He said, "That bitch will not put me in prison."
Now, as a detective, are you aware of what a protective order is?
Yes, I am.
What is that?
It's a document that someone can file with the court to basically have the court issue a restraining order requiring someone to stay away from that person.
And did you ever have a conversation with Miss Teitelbaum about filing a protection order?
Yes, I actually suggested that she do so and even provided her with a way to get the application.
Now, when you were in the defendant's apartment just 3 days before she went missing, what did you find?
a crumpled up piece of paper on the ground.
And what was the title of that piece of paper?
Petition for temporary protective order.
Now, I want to talk about your investigation into the defendant for the murder of Molly Teitelbaum. What did you do when Ms. Teitelbaum was first reported missing?
Well, first, I went to the defendant's apartment complex and looked around his vehicle.
And why did you look at his car?
Oh, I wanted to see if there was any physical evidence that would connect him to the disappearance of Molly Teitelbaum.
And was there any?
Yes. When I saw it, I kneeled down to look at the tires of his car, and they smelled like sulfur, much like the marsh that Molly Teitelbaum's body would be found in later.
And besides looking at the outside of the car, what else did you look at?
I looked inside the windows. When I did that, I saw that the back half of the car was absolutely pristine. The back seats appeared to have been vacuumed recently.
Now, other than the mud on the tires and the freshly cleaned back seat, was there anything else about the defendant's car that you noticed?
Yes, I saw that the trunk area was half covered by a large plastic tarp.
And are you aware of how the body was found in the marsh?
Yes, the body was wrapped with a tarp.
Did you confront the defendant about this physical evidence?
Yes, I did.
When?
That very same day.
How?
I knocked on his door and he opened it.
And what did you tell the defendant?
I told him that Molly Teitelbaum had been reported missing.
How did the defendant react to that?
Well, he wouldn't make eye contact with me and he didn't say anything.
And what did you ask the defendant about his whereabouts before she went missing?
Because of the mud that I'd seen on that truck, I asked if he had been to the marsh recently.
And what did the defendant say?
He said he had gone fishing at the marsh in Waukegan.
Where?
He couldn't tell me exactly where, just that it had been in the marsh.
And who had he gone fishing with?
Couldn't tell me that either.
What did you do with that information?
Well, we then went and searched the marsh for 2 days, but unfortunately didn't find anything.
And what did you do after the search of the marsh?
I obtained a search warrant for the defendant's apartment.
What were you looking for during that search?
I was looking for anything, fit the fishing equipment to corroborate what the defendant had told me, and anything else that could be relevant, such as Molly Teitelbaum's clothes or personal belongings. Really anything that could have helped our investigation.
Did you find any fishing equipment?
No.
Did you find the baseball bat that you'd seen before?
No, ma'am, I didn't. I looked all over the apartment, but I couldn't find it anywhere.
What items of Miss Teitelbaum's did you find?
Well, the apartment looked like it had been scrubbed clean. It was in a completely different condition than the last time I had seen it. I couldn't find any of her clothes or her laptop or her phone or any other personal items besides a necklace.
And where was that necklace?
Hidden on top of very high cabinets. When I saw it, I took a photograph of where we found it and of the necklace itself.
Your Honor, I'm referring the witness to Exhibit 21 on page 80 of the record. Let me know when you're there, Detective.
I'm there.
Do you recognize Exhibit 21?
Yes, I do.
What is it?
Photos of the necklace and the location where I found it.
Are those photos fair and accurate?
Yes, they are.
Your Honor, I offer Exhibit 21 into evidence.
Mr. Tang? Any
No
objection?
objections, Your Honor.
Okay, third minute.
Permission to publish?
Yes, ma'am.
Explain to the jury where you found the necklace.
Sure, I found it hidden on top of those very high cabinets.
And could you describe the necklace?
Sure. As you can see, it's a pretty nice diamond necklace.
Did you confront the defendant about where all of Molly Teitelbaum's things were?
Yes, I did.
And where did the defendant say her personal belongings went?
He said he got rid of them all.
And why did the defendant say he got rid of them all?
He told me she wasn't coming back.
Objection, Your Honor. Speculation.
That's overruled.
What did the defendant say? Why did the defendant say he got rid of all of your belongings?
He told me that she wasn't coming back.
During your interview with the defendant, did he tell you how he felt about Molly Teitelbaum?
Yes, he told me that he was angry with her.
And did the defendant tell you the last time he saw Molly Teitelbaum?
No. He admitted that he had seen her just 3 days before she went missing, but when I asked if he saw her again, he said, I don't know.
And what did the defendant say happened to Miss Teitelbaum?
He kept claiming he didn't know, but he kept making comments about her being hurt. It was weird because at the time, we didn't know yet about the body that would be found in the marsh or whether anything had happened to her.
And what exactly did the defendant say?
He suggested that maybe someone she met had killed her.
Had you mentioned to the defendant that she'd been hurt?
No,
Had you told the defendant she'd been killed?
not at all. This was 3 whole years before the body would actually end up being found.
And who was the first person during that interview to mention that Molly Teitelbaum had been hurt?
The defendant.
No further questions.
Mr. Shane?
Yes, Your
Ready?
Honor. May I proceed?
Yes, sir.
Good afternoon, Detective Lavelle.
Good afternoon.
I want to start by talking about whether anyone saw Mr. Pastore commit this crime. Now, Detective Lavelle, you ran a thorough investigation, correct?
I did.
You didn't find a single eyewitness that saw Mr. Pastore kill Molly Teitelbaum.
No one came forward and said they did, no.
You didn't find a single eyewitness that saw Mr. Pastore loading a body into his car.
No.
You didn't find a single eyewitness that saw Mr. Pastore taking a body out of his car.
No.
You didn't find a single eyewitness that saw Mr. Pastore burying a body.
No, I did not.
Now, let's talk about whether there was any physical evidence in this case. In September of 2016, you searched Mr. Pastore's apartment, correct?
I did.
And you believe that Mr. Pastore killed Molly Teitelbaum with a baseball bat.
Yes.
You didn't find any of Molly's blood in Mr. Pastore's apartment when you searched it.
No, like I said, it had been completely cleaned.
You mentioned that it had been completely clean, but you didn't detect any bleach, did you?
No, I don't know when it was cleaned. All I know is that it had been cleaned.
And you believe that Mr. Pastore transported a body in his car.
Yes.
You didn't find any of Molly's blood in his car.
No, there was a large plastic tarp in the back of the car. And again, the back of the car had been thoroughly cleaned.
Now, you mentioned a tarp. Tarps are typically used to catch things.
I'm sure tarps can be used for a lot of things.
One of them being to catch debris and liquids, perhaps?
Possibly. Yes.
You didn't see any blood on that tarp.
I did not.
You didn't see any hair on that tarp.
I did not.
You didn't investigate the tarp because you didn't actually look in the car, did you?
No, I looked through the back window at the car.
Now, let's talk about the bat. Your Honor, permission to display Exhibit 18. It's already in evidence.
You may.
One moment as my co-counsel displays the bat on screen. We can go on without it.
I'm
Same back
sorry,
before.
I'm having technical difficulties. My apologies, co-counsel.
Detective Lavelle, on direct examination, you mentioned the baseball bat found next to the Jane Doe.
Yes.
And you believe that you had seen Mr. Pastore with a very similar bat beforehand.
Yes, it was the same bat.
You don't have a photo of Mr. Pastore with that bat.
No, I never got a chance to take them.
And the last time that you saw Mr. Pastore with a bat was in 2016, correct?
Yes,
So that was more than 5 years ago.
it was.
And when you saw Mr. Pastore with a bat, you wrote down police reports.
We did.
And in those police reports, you don't describe the bat as black.
I do not.
You don't describe the bat as metal.
I do not.
You don't describe the bat as having white and gold lettering.
No, it had all those things, but I didn't write it down.
You don't describe the bat at all in your police reports.
No, I say it was there, but I didn't go into detail about what it looked like.
And on direct examination, you mentioned that the bat was around 32 inches,
Yes.
but you never measured Mr. Pastori's bat.
Not exactly, no.
That's a no. You never measured that bat.
No, I didn't pull out a measuring tape and measure it now.
And you also never pulled out a measuring tape to measure the bat found next to Jane Doe.
No, we didn't.
So let's talk about whether Molly is actually dead. You believe that Jane Doe is Molly Teitelbaum, correct?
Yes,
And one way to identify a body is with DNA evidence.
that is the case.
And you searched Molly and Lorenzo's apartment for Molly's DNA.
Yes, again, it had been thoroughly cleaned.
So you didn't find any of Molly's DNA.
No.
But you were aware that Molly had recently stayed at her mother's place.
Yes.
You were aware that Molly had recently stayed at Sasha Nyland's apartment as well.
Yes, I knew that.
But you didn't try to go to Molly's mother's home to get one hair from a pillowcase.
No, I didn't.
You didn't try to go to Sasha Nyland's apartment to try to get a toothbrush from a medicine cabinet.
No, I didn't.
So let's talk about where Molly might have actually gone. After Molly disappeared, you spoke with her best friend in the whole world, Sasha Nyland.
Yes, I did.
And after speaking with Mr. Nyland, you believe that Molly might have gone to a shelter.
That's where Mr. Nyland indicated she intended to go. Yes,
And so you called several shelters,
I did.
but you never visited a single shelter.
No, I gave them a description of her, but I never visited the shelter.
You gave them a description of Molly Teitelbaum.
Yes, to see if they had seen her.
Detective, you can't tell us how tall Molly is.
No, I cannot.
You can't tell us how much Molly weighs.
No, I cannot.
Your Honor, permission to display Exhibit 23 if technology will allow.
Yes, sir.
Authority and evidence.
You proceed.
My apologies. Technology will not allow. I'm very sorry. My computer is frozen. I'm so
Completely
sorry.
fine. But Detective Lavelle,
Was that the photograph of her at the onset of the case?
it was the photograph of Molly Teitelbaum at the beginning.
Okay, good.
Detective Lavelle, you had access to a photo of Molly Teitelbaum, correct?
Yes, I did.
You didn't give any of those shelters that photo.
I did not.
You didn't give that photo to any newspapers.
No, I didn't.
You didn't give that photo to any TV stations.
No, I didn't.
You didn't give that photo to anyone.
No, I did not.
Thank you. Past witness, Your Honor.
Any redirect? Ms. Coco?
Yes, Your Honor. Detective, why weren't you able to find any DNA?
Again, we searched all through Mr. Pastore's apartment. He had cleaned it thoroughly and thrown away all of her belongings.
No further evidence.
Okay. Next witness. How many
Yes, Your
witnesses? How many witnesses does the state have?
2 witnesses, Your Honor.
Okay. All right. Give me just 1 minute, okay?
Yes, ma'am.
Ready?
Yes, Your Honor. The state calls Mr. Casey Vidalis.
Mr. Vidalis, I'll assume you've been sworn. In your prior competitions, have the witnesses been sworn or they're just assumed to have been sworn in?
Constructively sworn in, Your Honor.
All right.
Good afternoon, Mr. Vidalis. Can you please introduce yourself to the jury?
Yes, good afternoon. My name is Casey Vidalis.
Mr. Vidalis, what do you do for a living?
I'm a senior forensic analyst for the Walkup Police Department. I've worked there for the past 17 years.
What does a forensic analyst do?
Forensic analysts help police in the scientific parts of criminal investigations and such as identifying bodies that are found.
Mr. Vidalis, what education did you need to become one?
I graduated with a double major in forensic science and biology from Loyola Chicago. And then I went on to get a master's degree in forensic science from Syracuse University.
Do you specialize in any particular area of forensic science?
I do. I specifically focused on odontology in school, and I published peer-reviewed articles on that subject.
Mr. Vidalis, what exactly is forensic odontology?
In plainest terms, forensic odontology is basically teeth matching. You collect dental records of a missing person and compare them to the dental data of an unidentified body. This is one way that we can help the police make identifications of bodies.
How reliable is forensic odontology?
It's very reliable. Forensic odontology is one of the most common ways to identify a decomposed body.
Generally, why would you use forensic odontology or teeth matching, as you put it, rather than DNA?
So the body of a person and its DNA decomposes much faster than the skeleton and the teeth. In a situation where the body is decomposed, DNA is usually unavailable. But since the teeth are still there, you're able to use odontology to make an identification.
Mr. Vidalis, how did you become involved in this case?
I was asked to identify a female body that was recovered from a marsh in our town right here in Walkup.
What was the condition of this body?
She was clearly very decomposed.
And how were you able to identify this decomposed body?
I used forensic odontology to look for a positive ID of the body.
Your Honor, pretrial order number 9 does not require that we formally tender Mr. Vidalis as an expert, but now that we've laid appropriate foundation to show his expertise in forensic analysis, would you like us to tender Mr. Vidalis or proceed with our examination?
Ms. Fields, do you have any objection to him being designated as an expert?
Your Honor, in this jurisdiction, we aren't allowed to formally tender as experts. Instead, we just lay the necessary foundation and then offer that opinion. I do have an objection, though, to this at this time, this witness offering an expert opinion, if I can be heard on that matter.
Mr. Narco, anything you want to add to that before we give her the field, give her the floor?
Yes, Your Honor, she's correct. Yeah, pretrial order number 9, as I said before, is the one that requires that we do not need to formally tender Mr. Vidalis.
Okay. Go ahead, Ms. Fields. Do you have any questions before we go? Go forward.
Yes, Your Honor. This witness at this time cannot offer an expert conclusion under Rule 702C. The proper foundation has not been laid. Although this witness has testified that forensic odontology is reliable, that is just a general statement about the type of analysis. He hasn't gone into any detail about exactly what tests were run, and if I may proffer.
Go ahead.
This witness will testify that the specific test that he did was to run it through a computer algorithm and a manual examination. We haven't heard anything about the reliability of that algorithm, about the computer algorithm he used, or about his manual examination. I just asked that that foundation be laid before this witness give an expert conclusion.
May I
Mr.
respond,
Narco?
Your Honor?
You may.
Your Honor, this witness has already testified to the years of experience as a forensic analyst. Furthermore, they testified to the specialized education they obtained to become a forensic analyst. And this witness has already testified to publishing peer-reviewed articles on forensic odontology. Your Honor, we have laid appropriate foundation to show Mr. Vidalis' expertise in forensic analysis. If permitted to testify, Mr. Vidalis will show that he applied reliable principles of forensic odontology in this case. However, pursuant to Rule 705, this witness can give an opinion without first testifying to the underlying facts or data.
Okay. The objection is overruled. You can proceed, Mr. Narco.
Mr. Vidalis, who was the female body in the marsh?
It was Molly Titelbaum.
How did you come to this conclusion?
I took a 3-step procedure. First, we ran a computer analysis, and then I did a manual analysis to look for both impossible directional changes and manually for those points of concordance that the computer had found.
Mr. Vidalis, that's a lot of words. Would it help to create a chart to help explain the steps that you took?
Yes, I think a chart would be very useful.
Your Honor, permission to have Mr. Vidalis create a demonstrative opposing counsel has seen this during pretrial.
Go ahead.
Now, Mr. Vidales, let's walk through the 3 steps. What was the first step?
The first step is to run a computer analysis.
And how did you run this computer analysis?
We used a computer algorithm.
Can you describe to the jury what that computer algorithm is?
Sure, it's a computer algorithm that helps compare dental records of missing individuals against dental records of other people. In this case, it took Jane Doe's records and compared it to records of all missing people in the state of Melodia.
How reliable is this computer algorithm?
The program I use is very reliable. In published studies, this algorithm has had a high success rate, and one study actually shows that it has a 100% success rate at identifying bodies.
In this reliable computer algorithm, who did it say Jane Doe was?
So that Jane Doe is Molly Teitelbaum.
Mr. Vidales, let's talk about the second step you took. What was that step?
So after the computer program identified Molly, I performed a 2-part manual analysis to verify the computer's result.
What was the first part of this manual analysis?
I looked for what's known as impossible directional changes.
What does impossible directional changes mean?
It's a sort of fancy way of saying differences. Basically, what I'm looking for are major differences in the teeth that would signal to me that this isn't a match.
Mr. Vidales, did you find any impossible directional changes or differences between Jane Doe and Molly Teitelbaum?
No, I did not.
What does it mean that you didn't find any impossible directional changes between Jane Doe and Molly Teitelbaum?
It means that there are no differences between Molly and Jane Doe's record that would exclude a match. And it means I can move on to my final step.
What was that final step?
That's a step where I manually look for the points of concordance or unique similarities between the teeth.
How did you manually look for unique similarities between the teeth?
I compared the x-ray of Jane Doe to the x-ray of the person the computer algorithm had identified, that being Molly Teitelbaum.
Now, Mr. Vidales, did you find any unique similarities between Jane Doe and Molly Teitelbaum?
Yes, I did.
How many unique similarities did you find?
I found 12 points of unique similarities.
And for reference, Mr. Vidales, is 12 points a lot?
It is. I generally refuse to declare a positive match without at least 7 points, so 12 points is above my standard.
How did finding these 12 points of unique similarities affect your opinion?
It confirmed for me that this body that was found is in fact Molly Teitelbaum.
Your Honor, permission to mark this chart as Exhibit P1 and preserve for use throughout today's trial?
Yes, sir. Any objections first? Ms. Fields?
No objection, Your Honor.
Okay,
Yes, Your Honor. Mr. Vidales, you mentioned earlier that you used the x-ray of Jane Doe and Molly Teitelbaum. I want to take a look. Your Honor, permission to publish Exhibit 3, which has been pre-admitted pursuant to a pretrial order?
any objections?
No objection, Your Honor.
Okay, go ahead.
Mr. Vidales, we're looking at Exhibit 3 now. What is it?
So those are the x-ray records of Jane Doe and Molly Teitelbaum that I used for my manual analysis.
Let's focus on figure 1A for a minute. Starting with the figure on the right, what is that?
The right side of the image labeled post-mortem, meaning after death, that's the x-ray of the body that was found in the marsh. I referred to it as Jane Doe before I was able to identify it as Molly Teitelbaum.
And the figure on the left, what is that?
So the left side of this image labeled antemortem, meaning before death, is the x-ray of Molly Teitelbaum.
Now, dealing with decomposed bodies like this one, do you ever face difficulties in your analysis?
I absolutely do, and this case was no exception, actually.
What do you mean by that?
Well, my job is to identify bodies that the police have found, but I'm not there for every step. I'm not part of the investigation. I'm not part of the team recovering the body. So unfortunately, what that could mean is that things aren't always done exactly the way I'd like them to be.
Now, in this case, what was the difficulty here?
There's something called a signal distortion on the left side of the postmortem image, which is the left side of the mouth. It was caused, I believe, this time by the x-ray process when the coroner didn't use a proper fixation system to hold the mouth in place.
Mr. Vidalis, can you show us on figure 1A where the signal distortion is?
Yes, I'll circle that area in blue, bottom left corner.
Your Honor, let the record reflect that the witness circled in blue the bottom left of the post-mortem x-ray.
Yes, sir.
Now, Mr. Vidalis, were you still able to use this x-ray to make an identification?
Yes, I was. Fortunately, most of this x-ray is unaffected by the distortion, so I could still use the image to make a comparison.
Now, let's focus on figure 1B for a minute. What are the green and red marks on this exhibit?
So as we look at figure 1B, the red circles are the concordance points in Molly Teitelbaum's x-ray, and those match the green circles in what was formerly called Jane Doe's x-ray.
Now, Mr. Vidalis, looking at this, we can see that all 12 of these points are on the right side of the mouth. What does that mean?
Well, normally I'm looking for 7 points of concordance across the entire mouth. So to find 12 points on only half the mouth really emphasizes how many distinct and unique similarities there were in this case.
Now, finally, Mr. Vidalis, after running the computer analysis, after manually looking for differences between Jane Doe and Molly Teitelbaum, and after manually looking for unique similarities, how confident are you that the body found in the marsh was Molly Teitelbaum?
Objection, Your Honor, under 702 may be heard.
You may.
Your Honor, this witness just testified extensively to a distortion that was on that image. He also testified that it didn't affect his manual analysis. However, we have not heard anything about how this distortion impacted the reliability of the computer algorithm. Therefore, before this witness elicits his final expert conclusion, I ask that we hear that this algorithm was still reliable given that severe distortion that he just told us about.
May I
Any
respond,
response?
Your Honor?
Yeah. Mhm.
Your Honor, counsel's argument goes towards the weight given to this expert's opinion, not the admissibility of it. Counsel will have the opportunity when I'm done to cross this expert and can ask about this signal distortion.
Maybe.
Furthermore, we did discuss this signal distortion in this direct.
Anything
Maybe
else,
heard,
Ms.
Your
Shields?
Honor?
Yeah.
Your Honor, my argument does not go to the weight, it goes to the admissibility. The jury cannot hear expert opinions that are not based on reliable data, in this case, or reliable methods. In this case, the jury hasn't heard that the computer algorithm method used by this witness was reliable. Therefore, it goes directly to admissibility.
Your Honor, may I respond?
Briefly.
Counsel is attempting to object to something that their own defense expert agrees to. Dr. Ford, in his report, agreed to the 100% success rate of this algorithm.
Maybe heard, Your Honor?
Yeah, I think I've heard enough. The objection's overruled. You can proceed. It's noted for the record.
Mr. Vidalis, I'll ask again. Finally, after running the computer analysis, after looking for differences between Jane Doe and Molly, and after looking for unique similarities between Jane Doe and Molly, how confident are you that the body found in the marsh was Molly Teitelbaum?
I'm very confident. I can conclude to a reasonable degree of scientific certainty that Jane Doe is Molly Teitelbaum.
No further questions, Your Honor. I pass the witness.
Ms. Fields?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Mr. Vidalis.
Good afternoon. How you doing?
Good. How are you?
Doing well, thank you.
Now, I want to start off by talking about whether you had enough evidence to identify the body in this case. Now, you were tasked with identifying the body found in Walkup Marsh, correct?
Yes.
You called it Jane Doe, like you said, because it was unidentified.
Yes.
And as a forensic analyst, you have multiple ways to identify a body.
Yes.
You could use DNA,
If available.
or you could use fingerprints,
Yes.
or dental records, right?
Yep.
But in this case, you didn't have any DNA, right?
No.
No fingerprints either.
No.
In fact, the crime lab didn't even measure Jane Doe's height, did they?
No.
So they couldn't compare Jane Doe's height to Molly Teitelbaum's height.
No, they couldn't.
So the only comparison you were able to do then was with dental records, right?
Yes.
Well, let's talk about the quality of those dental records. Now, you looked at an x-ray of Jane Doe's teeth, correct?
Yes.
but you didn't take that x-ray.
No.
A dental professional didn't take that x-ray.
No.
The coroner took it, right?
Yeah.
And when the coroner took that x-ray, they made a mistake, didn't they?
It appears so.
They didn't use the proper stabilization technique.
That's what I believe.
And what that means basically is that they didn't keep everything still while taking the x-ray image. Am I right on that?
Yeah.
Well, let's talk about why that matters. Your Honor, may we display a portion of Exhibit 3, which has already been pre-admitted into evidence?
Yes, ma'am.
Now, Mr. Vidales, this is an x-ray of Molly Teitelbaum's teeth, correct?
Yes.
And there's no signal distortion on this x-ray.
No, there is not.
And you can see all the teeth clearly.
Yeah. It's a pretty good picture.
Let's compare that to the x-ray that the coroner took. This is an x-ray of Jane Doe's teeth, right?
Yes.
It's blurry, right?
Yeah, there's some issues in the middle and the bottom left.
It's got a signal distortion.
It does.
And that signal distortion affected those left teeth.
Yeah, mostly affected the bottom left and the middle, but affected the top left enough that I didn't even want to try to make an identification over there. It just wasn't going to be scientific.
And it affected it so much that you actually wanted a higher quality image, correct?
Yeah, it's common to use a filter with these images, so I did go and put a filter on this image.
Well, I'm not asking what you did with this x-ray. I'm just asking whether you wanted a better x-ray, and you did, didn't you?
Yeah, I would have preferred one.
But you never got that better x-ray, correct?
No, I didn't get a better x-ray.
So the only x-ray you had of Jane Doe's teeth is this one here, the distorted x-ray.
Yes, and then I put a filter on it to clean it up a little bit.
Now, let's talk about the impact of that distortion then. So you took that distorted x-ray and you ran it through a computer algorithm, right?
Yes.
And like you said on direct, before making a match, you have to check for impossible directional changes, correct?
Yes, after you run it through the algorithm, impossible directional changes.
But isn't it true that that algorithm you use doesn't even look for impossible directional changes?
No, that's why you do it after you run it through the algorithm.
Well, let's talk about what you do after then. You do a manual examination, right?
Yes.
During your manual examination, you found 12 points of concordance.
Yes.
They were all in that right half.
Yep.
But isn't it possible, Mr. Vidales, that you could have an x-ray with 12 points of concordance and it could be a false match?
It is possible.
In other words, you could have two x-rays that have 12 points of concordance that actually come from two different women. Isn't that possible?
It's possible.
And you said you were only able to look on the right half. On that left half, you weren't able to find any points. Isn't that right?
No, but I was still able to make a comparison that basically ruled out any impossible directional changes.
Well, I'm not asking about your impossible directional change analysis, Mr. Vidales. I'm asking about concordance points. On that left side, you couldn't find any. Isn't that right?
That's correct.
And that's because it was just too distorted, right?
Yeah, I didn't want to take the chance of, not being thorough and scientific.
All right, Mr. Vidales, thank you for your testimony today. Your Honor, I pass the witness.
You redirect?
None based on that, Your Honor. May this
Okay.
witness be excused?
You may. Any further witnesses from the state?
State rests, Your Honor.
Okay. All right. Defense?
Your Honor, at this time, we would like to move for a directed verdict under Rule 29. May I be heard further?
You may. Go
Your
ahead.
Honor, at this point in the trial, no reasonable jury, even in the light most favorable to the prosecution, could find that they have proved their case beyond a reasonable doubt. They have to prove that Molly Teitelbaum is in fact dead, and we've already heard today that identification is based entirely on heavily distorted data. Additionally, regardless of the ID of the body, they have to prove that Lorenzo is responsible. The state has failed to put forth any forensic evidence linking Mr. Pastore to this case. Therefore, no reasonable jury could find that they've proved their case beyond a reasonable doubt, so we move for a directed verdict.
Any response, Ms. Coco?
Yes, Your Honor. As opposing counsel mentioned, the evidence should be viewed in the light most favorable to the state. And at this point, we have presented sufficient evidence for a reasonable jury to convict. We presented testimony that the defendant, Lorenzo Pastore, threatened to kill Ms. Titelbaum with a baseball bat that later turned up in the marsh with her dead body. We presented circumstantial evidence that the defendant tried to cover his tracks, and we presented expert testimony that a 100% accurate computer algorithm positively identified Jane Doe as Ms. Titelbaum. That's more than sufficient for a reasonable jury to find this defendant guilty.
Okay, anything else from either side? Ms. Fields, any response?
No, Your Honor.
Okay, all right, the request for directed verdict is denied. So next witness for opening statements.
Your Honor, we
Anything else?
move. Yeah,
Go
Your,
ahead.
yes, Your Honor. Your Honor, at this time, we move for a brief recess, if it's all right with both the other side as well as.
Yeah, how are we doing this schedule wise? Do you take a 5-minute break between? Okay.
Typically,
Is it
Your
five?
Honor.
Is it 5 minutes?
Yes, Your Honor.
Okay.
Anywhere from 5 to 10, whatever Your Honor prefers.
What do y'all need?
5 minutes is fine for us, Your Honor.
Okay, shot clock's running.
And could we get a time check from the bailiff during the break?
Yes. Why don't you check with her? I'll have her let you know. Okay.
Thank you, Your Honor.
Prosecution, you have 28 minutes remaining, and defense, you have 41 minutes remaining.
Thank you, bailiff.
How are you doing? Good?
Yes, Your Honor.
All right. All set?
Yes, Your Honor, before we proceed, I just want to confirm with my co-counsel, we did a little test during the break just to make sure that screen sharing is working, but I just want to get her on screen just to confirm. Ms. Fields, is screen share okay?
Is working right now. No promises 5 minutes from now, but as of now, it's working. Thank you for checking.
Fingers crossed.
Okay. Who's up next?
Your Honor, the defense calls Sasha Nyland to the stand.
Okay.
May I proceed, Your Honor?
You may.
Good afternoon. Please introduce yourself to the jury.
Hello, I'm Sasha Nyland.
Mr. Nyland, did you know Molly Teitelbaum?
Yes, I did.
How do you know Ms. Teitelbaum?
She's one of my best friends in the world.
And how long did you know Ms. Teitelbaum?
Ever since we were kids, we grew up together. We actually grew up playing soccer, and as adults, we remained kind of tight.
Ms. Fields, could you please display Exhibit 23? It's already in evidence. Mr. Nyland, who is this?
That's Molly.
And when was the last time that you spoke with Molly?
That was on September 13th of 2016.
And that last time that you spoke with Molly, did she tell you what her plans were?
Yes, she did.
What did she say her plans were?
And she said she was about to leave town.
Now, I want to start at the beginning, Mr. Nyland. Do you know Lorenzo Pastore?
Yes, I do.
How do you know Mr. Pastore?
He was dating Molly. They began dating in 2014.
And how long did they date for?
About 2 years.
And in that time, were you able to observe their relationship?
Yes, I was.
Based on your observations, how would you describe their relationship?
It was pretty bad.
What makes you say that it was bad?
Well, Lorenzo was possessive and controlling, and as the relationship progressed, it kind of got worse. He got aggressive and physically abusive with her.
Were you able to observe these incidents?
Yes, I was. Twice I showed up to their apartment, and he had hurt her, and she had to leave in an ambulance on occasion.
Now, I want to talk about how Molly reacted to this situation. When did Molly first tell you that she had a plan to leave?
That was back in 2016, while she was staying at my place away from Lorenzo.
Now, Mr. Nyland, could you please turn in your electronic notebook to Exhibit 15?
Yes, I'm there.
Can you tell us what is Exhibit 15?
This is a screenshot of Molly's search history on her phone, taken a few days before she disappeared.
How are you familiar with Molly's search history?
Well, she did this search while she was at my house, at my apartment.
Is this a fair and accurate copy of those searches?
Yes, it is.
Your Honor, the defense offers Exhibit 15 into evidence.
Any objections?
Objection, Your Honor.
Okay, it's admitted.
May we please display Exhibit 15 on screen, Your Honor?
You may, assuming it works.
Looks like luck's on our side.
Okay.
Mr. Nyland, can you tell us, what did you and Molly search?
We looked at how to create a safety plan in case there are any incidents with Lorenzo.
And what else did you search?
We also looked up domestic violence shelters that she could go to when she decided to leave.
Now, when you and Molly discussed this plan to leave, how specific was this plan?
She was pretty specific. She talked about when she would go get her belongings, her plan for changing her name, her plan for transportation, when she would go and where she would go.
Now, you mentioned 5 parts of that plan, and I want to break them down. Starting with the plan to get her belongings. What was her plan there?
Yeah, Molly had left some of her things at Lorenzo's place, and she had to go there, grab her things, and go.
You mentioned a plan to change her name. What was that plan?
Yeah, we planned for her to leave the entire state of Melodia altogether because we didn't want it to be notified in the paper. So she had to leave the state for her to change her name.
And you mentioned transportation. Did Molly own a car?
No, she didn't.
So if Molly didn't own a car, what was her plan for transportation?
Well, we planned for her to get a taxi. We didn't want her taking an Uber or a Lyft because that would leave a paper trail.
And you mentioned where she was going. Where did Molly say that she was going?
Well, first she said she was going to go to a domestic violence shelter in Melodia City. She would get herself figured out and then eventually leave the state.
Did Molly say where she was planning on going once she left the state?
Well, no, not exactly. She didn't tell me, but that was the point. She wanted to disappear.
And finally, you talked about when she would leave. When did Molly say she was planning on leaving?
She told me September 15th, 2016. And at that point, she's either going to leave town or press charges.
And have you seen Molly since September 15th, 2016?
No, I haven't.
Thank you. Your Honor, we pass the witness.
Mr. Nyland, Molly Teitelbaum was your best friend.
Yes,
You grew up together.
we did. We grew up playing soccer here in lockup.
You've been friends for years.
Yes.
And Ms. Teitelbaum told you about her plan to leave the defendant.
Yeah, she did.
And in fact, you spoke to her shortly before she went missing.
Yes, I did. I spoke to her on the 10th and the 13th.
And when you spoke to her on the 13th, she didn't tell you she was leaving.
But she told me she was going to go grab her things from Lorenzo's place, which is part of her plan to leave.
Well, what she actually told you was that she was going to meet with the police.
I'm sorry. She told me that she was going to Lorenzo's place on the 13th, which is part of her plan to leave.
And then she told you she was going to meet with the police.
Oh, I'm sorry. She told me that on the 10th.
Mr. Nyland, it's your testimony that Ms. Teitelbaum didn't say that Ms. Teitelbaum didn't tell you on the 13th that she was going to meet with the police to press charges.
She told me that on the 10th, September 10th.
Now, Mr. Nyland, you gave a statement in this case, didn't you?
Yes, I did.
And you were accurate.
I believe so, yes.
You were truthful.
Yes.
And you were complete.
Yes.
Your Honor, I'm referring the witness to page 29 of his affidavit.
I'm sorry, I don't have 29 pages in my affidavit.
29 of the record. And that would be page 4 of the affidavit.
Has it been admitted yet?
It is not. I can mark it for identification purposes as prosecution exhibit B.
Okay, are you trying to cross-examine him with it?
Impeach.
Impeach him? Okay.
Go
ahead.
It's your testimony that Ms. Teitelbaum told you she was going to meet with the police on September 10th.
Yes, she told me on the 10th. At that point, she thought Lorenzo wouldn't stop her unless she pressed charges or left town.
Now, I'm referring you to lines 29, to page 29, lines 23, line 23 of the record. Now, I want you to read along with me as I read aloud. At that point, she said she thought Lorenzo would not stop bothering her unless she left or he went to jail. I asked if she was thinking about finally pressing charges, and she told me that she was. She told me she was scared, but she set up a meeting with the police officer, and she was going to go on Friday to do all the paperwork for pressing charges. If this didn't work and the DA didn't agree, she would have to leave town. Now, skipping down to line 1 to 2 of page 30, that was on September 13th, 2016. I never saw Molly again. Those are your words, correct?
Yes, but you skipped a lot of portions there. I'm sorry. When you read at that point, that's on September 10th. And she told me on September 13th that she was going to Lorenzo's, which is part of the escape plan.
She also told you that she was going to Lorenzo's.
That was on September 13th. But she told me she's going to press charges on September 10th.
Mr. Nyland, before Ms. Titelbaum was going to meet with the police, she planned to meet with the police I'm sorry.
Okay.
Before Mr. Nyland went to go get her things, she planned to meet with the police.
Yes, on September 10th, she told me that, yes.
And she was going to press charges.
She told me she's going to press charges or leave town.
And when you spoke to Ms. Titelbaum, she did not say goodbye.
On September 10th? No.
She did not say goodbye on the 13th.
No, she just told me she was going to go grab her things.
Now, one of the things that Ms. Titelbaum had was a necklace.
Yes, she had her grandmother's necklace.
And it was a family heirloom.
Yes.
And Your Honor, permission to republish Exhibit 21.
Okay, go ahead.
This is that necklace.
Yes, it is.
It was her one memory of her grandmother.
Yes.
And you don't believe she would have left without it.
I would hope not, but I'm not sure.
Now, that last conversation that you had with Ms. Titelbaum, that was 5 years ago.
Yes.
And since then, Ms. Titelbaum hasn't written.
No, she hasn't.
She hasn't emailed.
No.
And you know that she kept a list with your contact information on it.
I'm sure she has my contact information.
You know that she kept a list with your contact information on it.
I'm sure she does.
Because you were one of the people that she felt safest with.
Yeah.
But Ms. Titelbaum hasn't called you.
No, she hasn't.
And she hasn't texted you.
No.
Now, Mr. Nyland, Ms. Titelbaum threatened, or Mr. Pastore threatened to kill Ms. Titelbaum before, didn't he?
Yes, he did.
Your Honor, I'm referring the witness to pages 3 and 4 of Exhibit 11 on page 53 and 54 of the record.
What is it you're doing with 53 and 54?
I'm referring the witness to them. I'm going to lay the foundation.
Okay, just so I understand, does Mr. Nyland have a copy of that in front of him while you're cross-examining him?
Yes, Your Honor.
Okay.
I can constructively publish if you would like.
No, that's okay. Go ahead.
No, I'll constructively publish it anyway for the witness.
Okay.
Now, Mr. Nyland, these are the text messages between you and Ms. Titelbaum on April 9th, 2016.
Yes, they are.
And they're fair and accurate.
Yes.
Now, I offer these text messages into evidence.
Any objection?
Who would object under hearsay, Your Honor?
Response?
Yes, Your Honor, these are not hearsay, they're present sense impressions. If you take a look at these text messages, Ms. Titelbaum is clearly telling Mr. Nyland what's happening as it's happening.
Let me just give me a minute to take a look at them.
Of course, Your Honor.
And just so I understand, is it Mr. Nyland on the other end of these?
Yes.
So his statements are in blue.
Yes, Your Honor.
Okay, all right. All right, the objection's overruled. It's admitted based on the present sense impression.
May I be heard, Your Honor?
Published before the jury.
Go ahead, Mr. Shang. Hold on a second.
The defense would ask that any descriptions that are not present sense impressions be redacted. For example, I can't, he will kill me. No, please don't, he will hurt me. These are not present sense impressions.
Let me just look, hold on a second. Tell me where you're looking, Mr. Shang. Is
Yes,
it
Your Honor. On the left text message, it would be the second text message in gray. I can't, he'll kill me. The very last text message, no, please don't, he will hurt me. These do not describe present impressions.
Okay, Ms. Coco, any response?
Yes, Your Honor. These are statements of a party opponent. If you take a look, she's saying that the defendant is telling her he might have to kill her anyway if it keeps bleeding.
Okay, wait, stop for a second. It's a statement of a party opponent?
So these statements here, Ms. Titelbaum is simply relaying what the defendant is saying. So those are both present sense impressions and statements of a party opponent.
Where is it? Where in the text message is what the defendant is saying?
Can you see my cursor, Your Honor?
Pardon me?
Are you able to see my cursor?
I do, yeah.
Okay, right here. Ms.
Okay.
Titelbaum says, I can't, he'll kill me.
But that's not what he's saying.
I'm sorry?
He's not saying that. It's what she's saying.
Well, if you keep reading, it says he might have to anyway if it keeps bleeding. He says it looks too bad. People will know and blame him.
Your
But
Honor, may I be
it's,
heard?
yeah, go ahead.
We are not objecting to any of those statements, merely the ones that I pointed out that are not present sense impression. I can't, he will kill me. And the very last text message on that side, no, please don't, he will hurt me. Any statements regarding as to what my client would do in the future?
Okay,
Your
anything
Honor.
else, Ms. Coco?
Yes, what I'm pointing out is that this statement, I can't, he'll kill me, is based on what the defendant is saying. He's saying, I might have to kill her anyway if it keeps bleeding. And then the second one was, he'll hurt me. Again, he's saying he might have to anyway if it keeps bleeding. It's based on the defendant's statements.
Okay, for purposes of this competition, the objection's overruled. The objections are noted and very well made. You can proceed.
Yes, Your Honor. Now, Mr. Nyland, I want to go through these, permission to publish before the jury.
You may.
I want to go through these text messages. Now, just for clarity, the blue text messages are you,
Yes, they are.
and the gray texts are Molly.
Yes.
You told Miss Titelbaum to call 911.
I did.
She said, I can't, he'll kill me.
Yes.
And in fact, according to Miss Titelbaum, he said he might have to anyway.
I believe that was the next text. Yeah.
It looks too bad. People will know and blame him.
Yes.
So you told her you would call 911.
I did call 911.
And Miss Titelbaum said, no, please don't. He will hurt me.
I still called 911.
Right. She said he's pounding on the wall saying no one can see it.
Yes, that's what she says.
And he has to finish what he started now.
Yes.
Now, that's when you called the police, correct?
Yeah, I called 911.
You also went to the defendant's apartment.
I did. I was concerned for Molly, so I rushed over as soon as I could after I called the police.
And when you asked the defendant what the hell he did to Molly, he said, her face was just too messed up. I didn't want to go to jail.
He
Correct?
said that, yeah.
No further questions.
Anything else, Mr. Chang?
Yes, Your Honor, brief redirect.
Go ahead.
Mr. Nyland, the prosecution asked if Molly contacted you after she disappeared. Was calling and texting you a part of the exit plan?
No, it wasn't.
Thank you. Your Honor, we pass the witness.
Okay, next witness. All done with this witness?
Yes, Your Honor.
Okay.
Yes, Your Honor. My apologies. I am frozen again.
It's okay.
It says you can't start your video because the host has stopped it. I'm so sorry. Is there?
That's okay. No, there's no need to apologize. I think we've kind of planned for this. Let's just see if we can get you reconnected. It won't count against you.
Great. Thank you, Your Honor.
Take a deep breath.
All right.
Are you good?
And can you see me now?
I can.
All right.
See you and I can
Tech
hear
is
you.
not on my side today. All right.
Okay.
All right, Your Honor, at this time, the defense calls Dr. Morgan Ford to the stand.
Okay.
May I proceed?
All right. Dr. Ford, I'll assume you've been sworn in.
Good
You can
afternoon.
proceed.
Good afternoon, doctor. Could you please introduce yourself to the jury?
Good afternoon. My name is Dr. Morgan Ford.
And what do you do for a living?
Well, I'm a forensic scientist. I specialize in forensic victim identification.
What is forensic victim identification?
Well, in most homicide cases, victims can be identified by next of kin, but sometimes that's not possible. So in those cases, we use science to try to identify the victim. That might be fingerprints, DNA, or dental records.
And how are you involved in today's case?
I was asked to examine whether the Jane Doe body is actually Molly Teitelbaum.
Before we get to your conclusion, I want to talk about your qualifications. What degrees do you hold?
I have a bachelor's in chemistry from Yale. I also hold a PhD in forensic science from West Virginia University.
How many years of experience do you have?
About 28 years at this point.
Could you summarize those 28 years for us?
Well, sure. Well, I started in the state crime lab here in Melodia, actually solving cases. I then became a professor at the University of Melodia, teaching about various forensic tests. And now I run my own forensic science consulting firm, where I review the work of police investigators.
And do you typically testify for the state or the defense?
Oh, I've never been hired by the state. They have their own team of forensic investigators.
And are you published on the topic of forensic victim identification?
Yes, I am, multiple times.
And have you ever been recognized in a court of law as an expert on forensic victim identification?
Yes, 17 times previously.
Well, let's talk about how you formed your conclusions. What materials did you have for your analysis?
I was given the reports from the 2 state investigators. I also had the autopsy and the death certificate for Jane Doe. And I was also provided with the dental images taken of Molly Teitelbaum and Jane Doe. And that was more than enough information.
What method did you use for your analysis?
Well, I conducted a review to determine the accuracy of the prosecution's identification. That meant analyzing the very same materials that the prosecution's expert did.
And is this a reliable method?
Yes, it's considered standard in the field for reviewing victim identifications.
And did you reliably apply that method?
Yes, I did.
So, doctor, what was your conclusion regarding the identity of the body in the marsh?
I concluded that the evidence collected by the police is not sufficient to identify the victim.
Let's talk about why the evidence wasn't sufficient to identify the victim. Starting with the first type you mentioned, fingerprints. How can fingerprints be used to identify a body?
Well, every person has a unique pattern of ridges on their fingertips. And if you compare the victim's fingerprints to the fingerprint records of missing persons, you can see if there's a match to identify the victim.
Your Honor, permission to display Exhibit 2, the autopsy, it's already been pre-admitted into evidence.
Any objections? Mr. Narco?
No objections, Your Honor.
It's admitted. Go ahead.
So, doctor, why couldn't fingerprints be used to ID the body in this case?
Well, simply put, there were no fingerprints. The autopsy describes advanced decomposition, so there were no fingerprints to analyze.
All right, well, let's move on to that second way to ID a body that you mentioned, DNA. What is DNA?
Well, DNA is genetic code. Every cell in our bodies has the exact same unique code. You can think of it like a phone number, except instead of 10 digits, we all have somewhere in the realm of 3 billion.
And you mentioned body decomposition earlier. How does that impact DNA analysis?
In a slightly different way compared to fingerprint analysis. We're able to extract usable DNA even after advanced decomposition has set in.
Well, then why couldn't DNA analysis be used to ID the body in this case?
Well, because the police didn't collect Miss Teitelbaum's DNA when she went missing, and they didn't collect DNA from the Jane Doe found in the marsh.
So you say the police didn't collect Molly's DNA after she went missing. Why is that significant?
Well, if the police had collected one toothbrush, one shirt with her sweat on it, a single hair from a pillowcase, we could run a match, an analysis to determine if Jane Doe is actually Molly Teitelbaum.
Well, you also said that the police didn't collect DNA from Jane Doe, but if they didn't have Molly's sample, why does that matter?
Well, the state keeps a database of missing persons, which includes their DNA samples. If the police had collected Jane Doe's DNA, they could have run it through that system and compare it to every other missing woman in the state. We don't know if Jane Doe is actually one of the other missing women because the police never checked.
Well, doctor, how hard is it to collect DNA from a body?
Typically not hard at all. Even with a decomposed body, you only need a single tooth to collect a sample. The police took an x-ray of Jane Doe's teeth, so they clearly had access to them, but they never took a DNA sample. It's difficult to understand why the police didn't even try to identify Jane Doe using DNA.
Well, let's move on to that third way to ID a body that you mentioned, dental records. Doctor, why couldn't dental records be used to ID the body in this case?
Well, because the dental x-ray used had a severe signal distortion.
What's a signal distortion?
Oh, it's a defect in the x-ray. It's kind of like taking a picture of a race car at top speed. If you don't use the right technique, the image will come out all blurry.
And what causes a signal distortion?
Usually improper technique when taking the image. The state's forensic analysts indicated that the coroner failed to use the proper stabilization system while taking the x-ray.
Now, doctor, would a visual aid help you explain to the jury how those distortions impacted the ability to identify the body?
Yes, that would be helpful.
Your Honor, permission to display a portion of Exhibit 3, which has been pre-admitted into evidence?
Any objections?
No objections, Your Honor.
Okay, go ahead.
Now, doctor, what are we looking at here?
Well, this is the only x-ray that the state took of Jane Doe. I'm marking it as Jane Doe dental image. The area in the center of this image, highlighted by the yellow box, that's where the teeth are.
And where's that signal distortion that you mentioned?
Well, there are actually two areas that are distorted. The first is a blur of the lower incisors. That's marked in a red box.
What about the second one you mentioned?
It's the entire left half of the mouth. That distortion is marked as well.
So how do these signal distortions impact the ability to identify a body?
Well, this is literally the only evidence we have to identify the victim, and it's both compromised and incomplete. Those distorted areas are completely unusable. So the police are trying to identify Jane Doe from an x-ray that's mostly blurry. You need more data than that before you can make a positive ID.
Your Honor, permission to preserve this as a demonstrative aid to be used for closing arguments?
Any objections?
No objections, Your Honor.
Okay,
Now, doctor, we heard from the state's analyst, Casey Vidales, that he used both a computer algorithm and a manual examination. Which of those two analyses would be impacted by those signal distortions?
Both of them would be. The algorithm is state of the art. It's the current tech that we have. Mr. Vidales certainly seems qualified, but I'm not aware of a single forensic test that can overcome data this bad.
Thank you, doctor. Your Honor, I pass the witness.
May I proceed, Your Honor?
may.
Dr. Ford, as a forensic scientist, you know that bodies decompose over time,
Yes, that's correct.
but the body that was examined in this case was in the marsh for 3 years.
That's the estimated time, yes.
And during that time, it began to decompose.
That's right.
And because of these conditions, Dr. Ford, you don't know if DNA from this body would have survived.
I can't be absolutely certain without being able to actually analyze the body myself.
Which is why Mr. Vidales used forensic odontology.
Yes, that's what he used to perform an analysis.
Well, let's talk about forensic odontology. That's the process of essentially matching teeth from an unidentified body to a missing person.
Yes, that's right.
You use forensic odontology in your business.
I often do.
Do you consider it reliable?
It's typically reliable if you have good enough data.
You would agree that one of the most reliable ways to identify a body is by matching someone's teeth.
That's one way you can, yes.
Well, let's talk about how Mr. Vidales used forensic odontology. On direct, you said you reviewed Mr. Vidales' report. Is that right?
Yes, that's correct.
So you know that he went through 3 steps in his analysis.
That's right.
The first step was to run the computer analysis.
Yes, he used the SERP algorithm.
The second step was to manually look for impossible directional changes.
That's right.
And the final step was to manually look for points of concordance.
Yes, that's correct.
Dr. Ford, do you agree that these 3 steps are the right procedure to follow?
Certainly.
Well, let's talk about what Mr. Vidales found following these 3 steps. Your Honor, permission to republish Exhibit P1, the demonstrative that Mr. Vidales created during his direct.
Yes, sir.
Dr. Ford, the first step was to run the computer analysis.
Yes, that was the first step.
You're familiar with the computer algorithm that Mr. Vidales used for this step.
Yes, I am.
Do you agree that the algorithm matched Jane Doe as Molly Titobaum?
That's what the algorithm said.
And Dr. Ford, you agree that this algorithm has a 100% success rate at identifying bodies?
There's one study that says that.
Dr. Ford, this 100% success rate applies even in difficult cases like this one.
That's my understanding.
Well, let's talk about the second step that Mr. Vidales took. He manually looked for impossible directional changes.
Yes, that was the second step.
What that means is he was looking for differences between Jane Doe and Molly Titobaum.
Right, such as a tooth regrowing. That's not possible.
Right. And Mr. Vidales did not find any impossible directional changes or differences between Jane Doe and Molly Titobaum.
That was what his analysis indicated.
Well, Dr. Ford, neither did you.
No, given how blurry the x-ray was, I was unable to determine if there are impossibility points.
Well, Dr. Ford, most of the mouth could be compared, correct?
Quite a bit of the mouth could be compared for parts of the analysis, sure.
The only parts that you couldn't use for the impossible directional changes was the lower incisors.
Right, those were completely blurred. You can't even tell the teeth apart.
For the part that you could compare, which you just said was most of the mouth, you didn't see any specific evidence of any impossible directional changes. Is that correct?
That's correct, yes.
Now, Dr. Ford, let's talk about the final step that Mr. Vidales took. He manually looked for points of concordance.
Yes, that was the third step.
What that means is he was looking for unique similarities between Jane Doe and Molly Titobaum.
Right, size, shape, angle of teeth.
Mr. Vidales found unique similarities between Jane Doe and Molly Titobaum.
Yes, he did.
Now, Dr. Ford, in your practice, you only require 8 points of similarities to declare a match, correct?
That's typically enough.
In this case, Mr. Vidales actually found 12 points of similarities between Jane Doe and Molly Titobaum.
Yes, he found 12 points.
And Dr. Ford, you yourself saw those same 12 points that Mr. Vidales saw.
I saw them indicated on the x-rays. I couldn't confirm or dispute them.
Dr. Ford, you saw the same 12 points that Mr. Vidales saw.
Well, I can see where he marked the 12 points on the x-rays. That's correct.
Well, Dr. Ford, all you need to manually look for points of concordance are the x-rays, correct?
Yes, that's correct.
Are you testifying today that you had the x-rays and could have manually looked for points of concordance and you didn't?
No, that's not what I'm saying.
So you saw the same 12 points that Mr. Vidales saw.
I saw where he marked the points. That's correct.
Are you testifying that you didn't look for points of concordance yourself?
No, I did, and I couldn't confirm or dispute what Mr. Vidalis found.
Dr. Ford, you wrote a report for this case, correct?
Yes, I did.
And in that report, you intended to be conclusive.
Yes, I was telling what the work was that I did in this case.
You intended to be accurate,
Yes,
truthful,
yes,
and complete.
right.
Dr. Ford, you even had an opportunity to review your report and sign it.
Yes, I did.
Your Honor, I'm directing the court counsel a witness to the witness's report, which starts on page 32 and ends on page 35.
Go ahead.
Dr. Ford, take a look through this report. Nowhere in this report did you say that you did not see the same 12 points that Mr. Vidalis saw.
Right. I don't say that because that's not what I'm saying now.
But Dr. Ford, you're an expert witness in the case that relies on forensic odontology, correct?
Yes, I am.
You had the same materials that Mr. Vidalis had to do the manual analysis to find points of concordance.
Yes, I was given the same materials.
Yet you didn't look for points of concordance?
No, I attempted the analysis.
Dr. Ford, if you attempted the analysis and you didn't find anything, that would be in the report, correct?
That's correct.
But nowhere in this report did you say you attempted it and you didn't find anything. Is that right?
Right, because that's not what I'm saying.
Dr. Ford, you just said you attempted it and you didn't find it. Am I having that correct?
No, not quite.
Dr. Ford, what is your testimony?
My testimony is that after looking at the x-rays, performing my analysis, I wasn't able to confirm or dispute the points of concordance. The x-ray, frankly, is just too blurry to accurately complete the analysis.
But Dr. Ford, you never, like I said, you never listed that in your report. Is that correct?
Well, I talk about the blurriness of the x-ray.
But you never said you couldn't confirm or deny the points of concordance.
Right, because I couldn't conclude either. I couldn't complete the analysis to a reasonable degree of scientific certainty.
No further questions, Your Honor.
Anything else, Ms. Fields?
Brief redirect, Your Honor.
Okay.
Now, Dr. Ford, the prosecution just asked you about concordance points. How did concordance points impact your analysis in this case?
Well, frankly, they don't. More than half of the x-ray is blurry. You need more than that to make a positive ID. It's like you can't make a positive ID from a smeared fingerprint. You just can't make a positive ID from an x-ray as distorted as Jane Doe's was.
Anything else, Ms. Fields? Is she frozen?
It appears to me that she might be frozen, Your Honor.
Okay, let's give her a chance to get back on.
Can you hear me?
Yeah, you froze it. You froze there for a second.
My apologies, Your Honor.
That's okay. Did you have a follow-up question?
Yes. Did you hear any portion? Did you hear the first question I asked?
Yeah, I think we got through that.
Okay, great.
And then you were frozen while he was answering the question.
I believe I heard his answer. So I just
Okay.
have one more question, Your Honor.
Okay.
Now, Dr. Ford, the prosecution also asked you about the algorithm success rate. How does the distortion impact that success?
Even the best algorithm that we have is unreliable when the x-ray is compromised like Jane Doe's is.
Thank you, Dr. Ford. I have no further questions. Your Honor, I pass the witness.
Okay. Anything else from the defense?
No, Your Honor. At this time, the defense rests its case in chief.
Okay. Anything else from the state?
No, Your Honor. We're ready
Okay.
to proceed to closing arguments, although we do request a brief recess.
Okay. What, need 5 minutes?
5 minutes.
What do we have on time on closing arguments for each side? And how do you want to do that? Are you breaking it up, or are you just going to do it all at once? Typically, my experience has been that the state goes first, defense has the opportunity to go second, and then the state can close.
Yes, so the state will present a closing and we have the opportunity to reserve time for rebuttal.
Okay.
But we would like to get a time check.
Okay, and is it the same individual that's doing the entire closing for the state?
Yes,
Okay, all right. 5 minutes enough?
perfect.
Yes, Your Honor.
Thank you.
Okay, all right.
For the time remaining, prosecution has 11 minutes and 32 seconds, and defense has 26 minutes exactly.
Okay. Does anybody need 26 minutes for closing arguments? All right. See you in 5 minutes. Okay, everybody ready?
Yes, Your Honor.
Okay. Just 2 seconds. Okay, state has the burden of proof, so they have the opportunity to go first, followed by the defense, and then the state can close. I think one side had 11 minutes, the other side had 26 minutes.
Yes, Your Honor. And the prosecution would like to reserve 1 minute for rebuttal.
Just 1 minute?
Yes, Your Honor.
How much, did you have 11 minutes left or 26 minutes?
11.
Okay.
And before we begin with closing arguments, Your Honor, we just want to confirm with the bailiff that because my co-counsel is having difficulties with technology, we were wondering if one of our witnesses could share their screen during my closing statements.
Sure. I'm fine with that. That's not a problem.
Great. Thank you.
So, Mr. Shang, are you doing all of closing?
I will be doing the defense closing, yes.
Okay. All right. And Ms. Coco, you're doing all of closing for the state?
Yes, Your Honor.
Okay. All right. Okay. Ready.
That bitch, she will not put me in prison. These are the words of the defendant, a man who ultimately became Molly Teitelbaum's killer. Because when Molly Teitelbaum finally got the courage to leave the defendant, he refused to let her go. Instead, he picked up his baseball bat and he struck her in the head over and over and over again until she was dead. And then when she was no longer breathing, when she didn't have a pulse, the defendant drove the lifeless body of the woman that he supposedly loved to a marsh, and he dumped her there like a piece of trash. For 3 years, her body was in that marsh. For 3 years, the defendant got away with murder. Members of the jury, the defendant may have silenced Ms. Teitelbaum, but you get to use your voice today by convicting the defendant of first-degree murder. Now, make no mistake, we've shown you that that's exactly what you should do today. Find the defendant guilty. We had to prove that the defendant acted willfully, deliberately, and with premeditation when he made the decision to kill Ms. Teitelbaum. And it's clear that we've met our burden when you look at why, when, and how he killed Ms. Teitelbaum. So let's start with why. The thing about domestic violence is that it's just that, domestic, between two people in the privacy of their own homes, behind closed doors. There's no witnesses and no video. And when a victim is killed like Molly Teitelbaum was, that victim can't tell you what happened. But Molly Teitelbaum was able to tell us what happened through text messages with her best friend, Sasha Nyland. Molly Teitelbaum knew the defendant would kill her if she reported him to the police. And that's why when Mr. Nyland told her to call 911, she said, "I can't. He'll kill me." Those texts let you see behind the closed doors at the fear that Molly Teitelbaum had. The fear that the defendant would kill her. But more importantly, they let you see the defendant's threats. The defendant refused to accept the consequences of his actions. And that's why he beat Ms. Teitelbaum in the head with a baseball bat after he found a crumbled up protective order on the floor. He refused to let her air his dirty little secret. And how else do we know that that's what happened? The defendant himself. Mr. Nyland told you that he confronted the defendant after the first time he attacked Molly. He yelled at him, "What did you do to her?" And the defendant responded, "Her face was just too messed up. I didn't want to go to jail." But that's not all he said. In the presence of the police officers, this defendant said, "That bitch, she will not put me in prison." This is why the defendant killed Ms. Teitelbaum. It was his plan, it was his intention, and he knew the consequences. So let's talk about when the defendant killed Ms. Teitelbaum. The last time that anyone heard from her, she was going to the defendant's apartment to grab her things and go. But that first step of the plan, it didn't give Ms. Teitelbaum the opportunity to escape to freedom and safety. The only person who had an opportunity that day was the defendant. The opportunity to make sure that she never aired his secret. Now, you don't have to just take my word for that, or even the detectives. Look at the physical evidence. Detective Lavelle went to the defendant's apartment right after Molly went missing because he knew that that was the last place Molly Teitelbaum was going. And what did he find? Without even knowing that Molly Teitelbaum's body would be found in the marsh, he looked at the defendant's tires and he noticed that they smelled like the mud from the marsh. The defendant was forced to admit that he'd been at the marsh right when Molly went missing. The defendant looked for other evidence, and without even knowing that Molly Teitelbaum would be found wrapped in a plastic tarp, he found one draped over the defendant's car. And when he went into the defendant's apartment, all of Ms. Teitelbaum's things were gone. There was no trace of her and no shred of her DNA. Now, opposing counsel in opening statement got up here and told you a story. Molly Teitelbaum put her laptop in her backpack, threw it over her shoulder, walked out the defendant's apartment, and never looked back. But members of the jury, there's a problem with that story. And that is that the defendant admitted that he was the one who got rid of all of her things. Now, why would he do that? Why would he feel the need to throw out her laptop, her clothes, her personal belongings? And the answer to that question is so simple. The defendant knew that he had to cover his tracks because he knew that she was not coming back. Because the only person who had an opportunity that day was the defendant. The opportunity to do what he said and finish what he started. Now I want to move on to how Ms. Teitelbaum died. Now, the defendant's words when interviewed by the detective tell you everything you need to know. The defendant was the first person to mention that Molly Teitelbaum had been hurt. And remember how she died. The coroner's report stated that she died of blunt force trauma to the head from an object like a mallet or a baseball bat. And this baseball bat was the baseball bat that was uncovered from the marsh. This was the same baseball bat that the defendant was holding when he yelled at Molly Teitelbaum through the bathroom door, "You better come out now so I can finish what I started." Now, that first time, Molly Teitelbaum was able to lock herself in the bathroom. But the second time, she wasn't able to hide. The defendant hit her in the head and she was crying so much that she couldn't speak. She couldn't tell the detective what had happened to her. But she gestured. And she gestured toward that baseball bat. Now, it's no coincidence that that baseball bat mysteriously disappeared at the same time Molly Teitelbaum and all of her other things did. The defendant threw it out, just like he did with everything else. And we know that that's the case because the next time Detective Lavelle saw that baseball bat, it was in the marsh next to Molly Teitelbaum's dead body, the same exact place where the defendant tried to hide it. Now, the defendant has come here today and he refuses still to accept the consequences of his actions. So he's raised the question of whether we know that Jane Doe is really Molly Teitelbaum. Members of the jury, how pathetic is that? How desperate to come here and tell you that the mid-20s female body found in the same walk-up marsh that the defendant admitted to going to, with the same weapon that he used to attack her with before, is someone else. It doesn't make sense. But that's what the defendant told you. So we had to bring an expert, and we did. That expert walked you through his 3-step analysis. He ran the records through a 100% accurate computer algorithm, and it declared a match. Then he looked for impossible differences between Molly Teitelbaum and Jane Doe. There were none. And finally, he found 12 points of concordance, more than enough by both experts' account to declare a match. Molly Teitelbaum will never go to work again. She'll never get to play soccer with her best friend. Her mother will never become a grandmother. And that's because this defendant refused to let her go. He silenced her. But you, members of the jury, you get to use your voice today. You get to tell the defendant, we were fair to you. We watched, we listened. And what we see and what we know is that this defendant intentionally killed Molly Teitelbaum with a baseball bat and then dumped her body in the marsh. The defendant may have gotten away with murder for 3 years, but you get to use your voice today, members of the jury. Find the defendant guilty.
Mr. Chang,
Yes, Your Honor. May I proceed?
you may.
Today, Molly's best friend in the whole world took the stand. And we asked him, did Molly tell you where she was headed? His answer, she didn't tell me exactly where she was headed, but that was the point. She wanted to disappear. Molly Teitelbaum hasn't been found because she didn't want to be found. Members of the jury, that's what this comes down to. Molly's gone, but she's not dead. But of course, as the defense, it wasn't our job to prove that. The prosecution had the burden of proof. The highest burden in our criminal justice system, proof beyond a reasonable doubt. But they haven't proven that Molly's dead, and they certainly couldn't prove that Lorenzo Pastore had anything to do with it. And that's because of 3 facts. Molly had a plan to leave, Molly left, and Lorenzo Pastore had nothing to do with it. Let's take those one at a time. Starting with fact number 1, Molly had a plan to leave. Now, members of the jury, we acknowledge that Lorenzo Pastore was abusive. We didn't try to excuse it. We didn't try to defend it. But his behavior is not evidence of what he did next. It's evidence of why Molly made a plan to leave. Members of the jury, you saw Molly's Google search history. More than 20 websites on how to leave an abusive relationship, on how to get to a domestic violence shelter. And this idea to leave became a plan to leave. You heard this from Molly's friend, Sasha Nyland. And let me say that again. Sasha Nyland is not Lorenzo Pastore's friend. He's Molly's friend. He has absolutely no reason to lie to you. And he told you Molly had a plan to leave. And this wasn't some vague plan. This wasn't a what if. This was a specific, detailed, 5-point plan. How she would get her things, how she would change her name, how she would arrange for transportation, where she would go, when she would go. But that last point is crucial. September 15th, 2016. On that date, she would either press charges with the police or leave. Now, no one has seen Molly since September 15th, and she never pressed charges. Which brings me to fact number 2. Molly left. No one has seen Molly since she said that she would leave town. Now, the prosecution says that it's because Molly's dead. But how hard did the police really look for Molly? Detective Lavelle knew that Molly was planning on going to a shelter, but how many shelters did he visit? 0. He knew that Molly was planning on going out of state. How many out-of-state shelters did he call? 0. Detective Lavelle had this photo of Molly. How many shelters received this photo? How many newspapers? How many TV stations? 0. It's hard to find someone when you're not really looking. Now, the prosecution also argues that Jane Doe is Molly Teitelbaum, but they didn't prove that today. Today, we heard about 5 different ways to identify a body. There's identification by a family member. This body was too decomposed. Identification with fingerprints. This body was too decomposed. Height. The crime lab failed to even measure Jane Doe's body. DNA. The police said that they tried to look for DNA in Molly Teitelbaum's apartment and weren't able to find any. But they knew that Molly had recently stayed with her mother. They knew that she had recently stayed with Lorenzo Pastore. Did they look for one hair on a pillowcase at Molly's mother's house? Did they look for one toothbrush in a medicine cabinet left at Sasha Nyland's? The police even thought that Lorenzo Pastore transported a body in his car. But you heard today that the police didn't even look in his car. All they did was go up to the window and take a peek. It's hard to find DNA when you're not really looking. So, identification by a family member, fingerprints, height, DNA, that just leaves dental records. And we did have dental records in today's case. Specifically, we had this dental x-ray, a blurry x-ray. Now, this is a clear x-ray. And meanwhile, this is what the prosecution wants you to rely on. The prosecution's expert admitted the coroner here made a mistake. This image is blurry because the coroner failed to keep the mouth steady when taking the image. Now, members of the jury, there's no easy way to say this, but how difficult is it to keep a dead body from moving? And when we say that this is flawed evidence, you don't have to take my word for it. The prosecution's own expert said, I wanted a better image, but this was the best that I had. Members of the jury, Lorenzo Pastore is on trial for murder. The best that I had isn't good enough. You heard from Dr. Morgan Ford that you cannot reliably make an identification based on less than half of a mouth. The prosecution has failed to prove beyond a reasonable doubt that Molly Teitelbaum is even dead. And for that reason alone, you must find Lorenzo Pastore not guilty. But there's one more problem with the prosecution's case. That brings us to fact number 3. Lorenzo Pastore had nothing to do with it. This is the story that the prosecution wants you to believe. Mr. Pastore killed Molly Teitelbaum in order to prevent her from going to the police, even though there is no evidence, none, that he even knew that she was planning on going to the police. How did he supposedly commit this crime? The police say that he beat her to death with a baseball bat without leaving a speck of blood a drop of DNA, or any physical evidence. And without a single eyewitness hearing a peep, then he moved his body to his car without leaving a speck of physical evidence, and again, no eyewitnesses, and then he buried his body in the marsh. No eyewitnesses, no physical evidence, nothing. Well, the prosecution says, well, Mr. Pastore admitted to recently being at the marsh. But this is where the prosecution wants to have it both ways. On the one hand, Mr. Pastore is a master criminal who's able to make forensic evidence disappear and avoid detection from all eyewitnesses. But on the other hand, he's a fool who freely admits to being at a crime scene. That's not reasonable. The prosecution talked a lot about a baseball bat. They said that this baseball bat was the key evidence against Mr. Pastore. No, this was their only evidence against Mr. Pastore. But this baseball bat didn't have Mr. Pastore's fingerprints on it. It didn't have his DNA on it. The only thing connecting Mr. Pastore to this baseball bat is Detective Lavelle's testimony. Detective Lavelle says, I remember seeing Mr. Pastore with a baseball bat just like this one. I remember. Now, members of the jury, Detective Lavelle saw Mr. Pastore with a baseball bat in 2016, more than 5 years ago. Set aside the fact that this bat is not unique, set aside the fact that we don't know how many people own a baseball bat just like this one. A 5-year-old memory of a baseball bat when Detective Lavelle never measured the length, when he can't name the brand of the bat. That is not proof beyond a reasonable doubt. The prosecution has failed to prove that Lorenzo Pastore was responsible for the death of Molly Teitelbaum. The law requires a verdict of not guilty. Members of the jury, we know that Mr. Pastore is not a very likable man. He was abusive to his girlfriend. But he is not on trial for domestic violence. He's on trial for murder. And his behavior isn't evidence of what he did next. It's evidence of what she did next. She left. We ask you to find Lorenzo Pastore not guilty because Molly Teitelbaum is gone. But she's not dead. Thank you.
Coco?
Your Honor. Defense counsel wants you to believe that Ms. Teitelbaum left, but they conveniently ignore 3 things. Number 1, the defendant admitted to getting rid of all of her things. Ms. Teitelbaum didn't leave with them. Number 2, Molly Teitelbaum left behind a necklace, her last memory of her grandmother. A necklace that her best friend, Mr. Nyland, told you he does not believe that she would have left without. And finally, Molly Teitelbaum hasn't contacted anyone in 5 years, not even her best friend. Mr. Nyland told you that Ms. Teitelbaum has a list with his contact information on it. Don't you think that if Ms. Teitelbaum was able to get away, that she would have called Mr. Nyland to let him know that she was okay? Of course she would have, but she couldn't because she was laying in a filthy marsh, gone because the defendant killed her.
Okay, that concludes our trial. Judges and competitors, if you can please turn off your videos. Judges, once all ballots have been submitted, I will come back on screen and ask you to turn your video back on to proceed with comments. Thank you.
All right, I'm going to turn off the YouTube channel at this time. We will come back to the YouTube channel later tonight at 7 o'clock to announce the winners of the All-Star Bracket Challenge. So for those of you watching on YouTube, this will conclude that part